to do testing, or there's other social distancing, whatever they want to require, if you're not going to have the shot.
Well, that is, I think it's encouraging. Now, this also goes back to the Sixth Circuit. Is there anything that you believe that the complainants can do at the Sixth Circuit to modify or get some securities in place as part of this, or will they also just accept what this ruling is?
Well, which side? Do you mean
On the medical side, the 5-4? It's still going back to the Sixth Circuit. Are they likely to try and get more definition there, or do something, or are they also likely just to accept this ruling?
Yeah, honestly, the Sixth Circuit, I would hope the judges there are going to read the tea leaves, which are pretty clear that this OSHA mandate is not going to prevail. And so when it comes back, I know Judge Larson must be feeling pretty good right now. She was the dissenting judge there, the Sixth Circuit. That was a 2-1 decision. And Judge Larson from Michigan, who has been in our Supreme Court in the past, wrote a great opinion. And I'm sure she's feeling very vindicated today in her decision. So most judges take the position that they have to follow rulings of the Supreme Court, and they will follow. And the Supreme Court's the ultimate court.
Good.
They're bound to follow their rulings.
I wanted to bring people up to date who are just joining on YouTube. Actually, it was my fault. We have so many connections on here now that I actually missed. It went to a second line where YouTube was. So I joined YouTube later. A lot of people are saying I didn't hear the intro. We will obviously post this over onto the comments on YouTube if you missed the first part. We have David Coleman joining us from the Great Lakes Justice Center, who is commenting specifically on the Supreme Court rulings, or both of them that came down today. And we were just discussing both the huge success at 6-3 and also the challenges that exist in the healthcare industry. So I'm glad that you all here are joining us. David, just I don't know, did you have any chance to read the email of the ruling that came down today in that Michigan case against the Iron Pig?
No, in fact, I just saw that you emailed it to me, and that's when I saw that you were doing this tonight at 7. So no, I have not had an opportunity to read it, but I'm looking forward to reading it.
Okay. Well, I got to tell you, and for the people here, I wanted to bring it up, but it was very interesting. First of all, the judge, which is a circuit court judge, Honorable Colin Hunter, out of Otsego Circuit Court, is the one who issued an opinion today based on an appeal that was filed by the Iron Pig restaurant. If you remember, the Iron Pig Smokehouse was one of those businesses who stood up and never closed their doors. It was one of those that stood up for in the scrutiny. They did not have a liquor license. They continued to serve, and they continued to be fined. And in the end, they still were forced to and ordered to pay a $5,000 fine specifically. And so they challenged that in court. And the ruling that came down today literally had the hair on my arm standing up. Now I realize, David, that when you read this, there are going to be parts of this I think you'll feel the same way about. But I thought it was really interesting only because I want to tie it together with what the Supreme Court said today. And that is, think of a regulatory agency like OSHA, who is defined and ordered by Congress in order to, basically to change any emergency temporary standards. Whatever happens, Congress had the authority over that regulating agency. Now you had the executive branch stepping in and basically asking them to take over not only creating these mandates, but enforcing them, not just to the individuals, but to the businesses, fining them to the point of shutting their businesses down if they did not follow the rules. Am I correct?
Right. Mm-hmm.
So under this ruling today, this judge is stating under numerous spaces in here, and I'm just going to jump to a couple of pages here because it is 30 pages long. Mm-hmm. But the bottom line is, first of all, is that the Iron Pig prevailed and their fine is completely waived. But I want to give you part of what he said in here, because he is saying that on November 15th, following the October 2nd Supreme Court determination that the director issued emergency orders at issue in the case of the authority, and this is involving, again, that MCL 2253. The order was a total of 8 pages in length and contained mostly single-page type. He goes on into this, and he goes through the different broad things that were issued in there, and that was the general capacities, the specific gathering restrictions in facilities, the gathering limitations at schools, colleges, universities, the mask requirements, all the different things. He says, all told, this 8-page order immediately imposed requirements on nearly every aspect of Michiganders' lives, even within the confines of their own homes, severely curtailing operations across nearly every sector of public and private businesses within the state, every public school within the state, and also subject to vast restrictions, making the reach of the order nearly total. Specifically, as it relates to the instant case, the order effectively instantly shut down, aside from takeout, a large portion of both restaurant business in an instant, giving as many restaurants did not have the space or capability for dining. In addition, by requiring businesses to enforce these directors' mask mandates and contact tracing requirements, businesses were forced to make a decision: either follow the order and guidance and undertaking the responsibilities and enforcing of these things, or basically shut their businesses down. Interestingly enough, what he is saying here is that he says the power of the director holds under 2253 is no mere filling in the details as stated by Justice Viviano in concurrence as part of the order on October 2nd. Rather, it is an overwhelmingly broad power to affect every aspect of Michiganders' private businesses and lives, lawmakers and framers, and the federal Constitution believed should be difficult because it poses a danger to liberty. Acting under the authority granted, however, is not difficult, as it required merely the determination and a pen stroke of but one individual, and allows for the unprecedented broad use of power to affect every aspect of daily life, such immense authority being exercised by an administrative official. In the end here, David, he is saying that he believes that that the legislature was at fault for not defining the parts of the order under the health order about gatherings and what they could limit and how broad they could limit or how they needed to be limited, which also leads me to the unlock 2 in limiting them to 28 days, because that, of course, was upheld by the Supreme Court. The second thing he says is he believes that until that is fixed, that portion of that healthcare code 2253 should be removed entirely from the Health Code Act.
Amazing.
And he goes on basically in here to talk about the fact that he believes that the governor, who had as an executive branch no authority beyond the 28 days to have issued this guidance, and that she had pivoted with the use of a regulatory agency to carry out her wishes.
Mm-hmm.
And is that not exactly what the Supreme Court said today?
Right. Yeah, it's similar arguments. I mean, it's under different laws and
yes.
our Constitution here and things like that, but the principle is the same. You're right.
There's a lot more, obviously. I'm not reading 30 pages. What I have to say, though, is that we do have some judges out here who are actually looking at the Constitution, not just the laws as they are written or as they're being used or abused. I guess my question for you is, because this does give hope for people like Marlena, it gives hope to other businesses who have been fighting these mandates. I'm not saying they're all in Otsego, but it is an interesting argument that is pretty darn strong that he has here. I don't know whether this ruling by the Supreme Court could potentially talk about it, but honestly, the legislature has not acted to further lock down or define and the other thing he talks about in here is emergency orders and the time in which they are implemented. And if we could just name the word epidemic, name the word climate change as an emergency, if we can just broadly use those terms and then utilize agencies to control all aspects of our life, if indeed it affects our constitutional rights and liberties, that should prevail.
Mm-hmm. Yeah, I'm going to read that decision with interest. I would expect the state will most likely appeal that to the Court of Appeals.
Yeah,
I'm sure. Then we'll see which panel gets it and where it goes from there. I'm sure it'll end up at the Michigan Supreme Court. But that's a great decision. I'm glad that there's at least one judge out there willing to stand up and say no. Enough's enough. That we don't live in an administrative, one-person rule state. And I think that's exactly what that judge is saying. You don't give that kind of authority to unelected bureaucrats. You just don't. To totally take over and control your lives and your businesses and your livelihoods. Who are they accountable to? They're accountable to no one, you know? And this is why elections matter. This is why elections for governor coming up and for attorney general and these types of races are going to be so critical coming up in just 9-10 months from now. We have to get out there. And I will say, I know people are upset with the legislature and how they don't do enough and things like that. I do know they have passed some laws and done some things. And of course, Governor Whitmer's vetoed them all. And they've done some election reforms. And of course, when the petition drive was done, the legislature passed it, you know, and it went right into effect. And the governor could not veto it. So I think we all agree that there are times we would hope the legislature would do more, you know, but I don't think they've been sitting back doing nothing. I think that there have been things and bills put on the governor's desk, and she just keeps vetoing them. That's why we have to have a change this fall in the election coming up.
We do. And you know, I feel like for those of you out there that are in that health field, you were and are the front line of this defense. I believe there will be future lawsuits that are going to, especially as the real science and data is able to be shared,
Right.
that natural immunity is going to be recognized. It is beginning to be recognized in certain aspects of society. It's even being recognized in professional sports, believe it or not, today.
Yeah.
And yet it's not being recognized specifically in our own healthcare systems or our agencies. But I believe that eventually natural immunity has to be recognized. And that obviously with the Omicron, I believe is going to create a much broader group of people that are and have antibodies to this particular virus, or at least the strains that could be dangerous.
Yeah, I agree. I think more and more is starting to come out just in the past week. So, you know, hopefully that'll start helping in a lot of these cases that are ongoing right now. I mean, we're preparing to file a number of different suits right now. Some over the mask issue over in the east side of the state. We have a First Amendment case involving a public high school that told a student he could not share his faith on the school campus at high school. He couldn't talk about his Christian faith. We're going to be filing in federal court on that case. So you're going to be seeing a lot of things coming down the pike here pretty soon.
Well, we appreciate you, David, and we appreciate your comments here. Where can people go to get your latest opinion? Is it available at the Great Lakes Justice Center, or where
Yes,
would they go?
it's being posted. I just talked to my son, Steven. He's an attorney. He was posting this hopefully in the past hour. So the analysis I did, and we go into a lot more detail of what was said in the opinions. But you can go to greatlakesjc.org, Great Lakes JC for Justice Center.org, and then follow it from there. It'll be posted, and you can see some of the other cases and things we're doing. So, Ron, it's always a pleasure to be with you. We appreciate so much the work you do, and Stand Up Michigan and everyone around the state. It's just, you know, we have to keep going. You know, we just can't stop. I mean, we've had some great successes. We've had some good wins last year legally, you know, here in Michigan especially. But it's not stopping, folks, you know, and we have to vote these people out of office to stop this assault on our rights. And then once we can get back and hopefully have control of some of these, you know, offices like governor, continue the legislature, we could start passing some laws that, now that we've seen what the Democrats will do once they get drunk on power, we can maybe get some laws in place that will stop that sort of thing in the future, at least blunt it a little bit, you know. And but I think these petition drives and things and getting the Constitution changed, all of this is important. But people shouldn't get discouraged. They shouldn't feel like, oh, I don't want to vote, it's not going to matter. No, it's really going to matter this fall.
Can I ask you one more question before you go, since I've got
Yeah.
your legal mind on here? I've been dealing at a national level with this issue in regards to potentially the Senate trying to abolish the filibuster.
Yes.
You've been following this, and of course, the Senate
Sure.
is trying to look to break the rules and either do a carve out or, in this case, potentially bypass the filibuster. Now, we've had today, Senator Sinema specifically said she will not bypass the filibuster, but indeed, what they're looking to do again is to federalize the elections, and what we
Right.
call is if this was to pass. The federal government could potentially oversee. It would ban voter ID nationwide. It would
Mhm.
do all kinds, as we say, it's a freedom to cheat bill. It's not a
Sure.
right to vote
It
bill.
invites fraud. It invites fraud, Ron. Honestly,
Yes. And
it's
so
ridiculous.
uh are you I wanted to ask your opinion. If they were to do this, let's just say they prevailed, they broke the filibuster and they passed this.
Mhm.
Could this be would this be upheld in the Supreme Court when the Constitution is so clear that the states control the elections at the
Yeah.
state level?
I mean, you would sure hope they would follow the Constitution. But, after today, I wonder about Justice Kavanaugh. And honestly, I would not count on Justice Roberts in a case like that. So if you have the three liberals and Justice Roberts, we can't lose Kavanaugh. He would be the deciding vote. I think Gorsuch, Barrett, Alito, and Thomas would all uphold the Constitution like they do. But I don't know. I guess Justice Kavanaugh is. We're just going to have to see. But I don't think it's a slam dunk. But I sure think the federal Constitution, our U.S. Constitution, is crystal clear. The states decide how they hold their elections and what they do. It's not a federal issue.
And
There is
so,
no, as Justice Sotomayor said earlier this week, that, well, what are you talking about? Federal power trumps everything. I could not believe what I was hearing. I mean, like, she had no concept of the difference between state police powers and the federal government's limited powers under our Constitution. They don't have the police power for health and safety and things like that in general, like the states do. And so for her to make that comment that she just didn't understand what the difference, I was astounded by that, as were many other conservative lawyers around the country. That's just hard to believe, that a sitting Supreme Court justice would say that.
well, and we used to put them on such a high level, all of them, conservative or liberal
Right.
appointees at one point in time. But when you heard them literally lie from the bench, you cannot tell me when he talked about 63,000 pages that were created for the justice who was making the comments about 750 million cases or 100,000 kids in the hospitals. There was no way in the world these people didn't know what they were participating in when they made those comments. I just am astonished that those comments were made from the bench in regard to the public hearing that happened last
Right.
week.
As were many, Ron, I'll tell
Yeah.
you. Well, thanks
Well,
again
we
for having me
appreciate
on.
you. Thank you very much, so much for joining, especially in the last minute. It means a lot to us. Have a great day, David.
All
And I
right.
put it up here in the email or in the chat so everybody can go there and read your article.
All right. Thanks so
All
much,
right.
Ron. Good to be with
Thank
you.
you. Yep. So, I mean, it's great when you have connections and you can get people to get on, because there is a legal mind, like I said, that's prevailed both at a state level, and even up to, of course, the Supreme Court of the state of Michigan. And he's won 7-0. He won for Carl the Barber. He won for many of these suits. He won for the Western Michigan sports kids who were going to be denied to play because of the so-called they were positive COVID and needed to sit out, and they won that particular case. A lot of times the cases are won and lost based on the arguments or the merits that are provided to them. Understand, the justices can only rule not on their own opinions, but on the facts that are laid before them and the merits and the angles in which people argue the cases. So it is important who you have represent you. And in the case of the Supreme Court, I can tell you from my very close connections with some people that were arguing the cases at the Supreme Court, that there were some arguments that were not argued that should have been, some merits that should have been shared, that they believe should have simplified this argument and may have very well helped with the healthcare situation. One thing I do want to talk to you a little bit about before we go, and I know we're at 45 minutes here, except for those of you on YouTube who've only been on 15, is that these are important issues, and the Supreme Court matters. And as you know, President Trump nominated 3 of these individuals. Those individuals, stayed strong in this 6-3 decision. We did lose Kavanaugh in the second decision. It is a narrow decision, and it is important who we nominate to the bench. It's also important to note that part of what they are protecting at the Supreme Court is the individual's rights and liberties, including if you run a business, who you can hire and who you can fire, and what you can ask of your employees if they work for you. If indeed they are an at will employee, you have to have no reason in order to terminate them. So it is important to note that, though, in some of these cases, while private businesses may institute ridiculous liberal philosophies, they are indeed those individual business owners' property and individuals' rights to decide who they want to work for them. And yes, there can be and should be lawsuits against discrimination and other things, because if it was in something else, they'd fight that. But on the Supreme Court side, you have to understand that they truly want to not make a mistake in one case or in one part where they step on all of the constitutional rights of individuals going forward. In other words, if the courts can overrule you as an individual, we get an opposite court, and then they step all over everything that individuals have. So every time they uphold individual rights and liberties, they do uphold it sometimes in a bad way, but it also protects it for other ways. I'm not giving them excuses here by any means, nor am I trying to not let you know how horrible it is that our frontline people are going through some of these choices and changes. I only would hope that there would be many doctors' offices, healthcare facilities that potentially would open, that would not regulate or take this money. But as you know, that's why they tie it to Medicare and Medicaid. What do you know isn't paid by Medicare and Medicaid today? Not many, right? So that is an argument that has to be fought. And then individually, everybody has to make a decision. I'm only saying, for those of you that have jobs in those, you have a difficult decision to make. If you can get the religious and medical exemptions, then everything should be fine, and they should not deny those. And if they attempt to, then by all means find a good attorney. And it is matter how you write those exemptions. And so make sure that you look those things up. So I want you to know that today was a good day for us in multiple areas, and for the Iron Pig, for those businesses that stood up, those individuals who risked everything. In some cases, they risked everything and they continue to feed their community. They continue to be a solution in their community, and they were singled out by our tyrannical governor and by our socialist attorney general in a way that singled out people like Marlena. And I am praying that this case will be upheld in the circuit court, which I'm sure, again, it will be appealed to. But this ruling has a real merit, and I hope that you get a chance to see it, that you will participate. It's also the reason that we need to be involved, and I'm going to do a separate one. I'm going to leave it with it now. In probably the end of this weekend, I'm going to do one on the petition initiatives. I've got an announcement to make on Unlock. I've also got a very important announcement. I'm just going to tease it right now, is that the Secure My Vote petition initiative is going in the mail starting a couple of days ago and over the next couple of weeks. If you signed Unlock 1, if you circulated at all Unlock 1 petition sheets, you are going to receive 2 petition sheets for Secure My Vote in the mail. And that is going to happen again. You should get those in this next 2 to 3 weeks max. I'm going to be doing a series of lives on this because it is vital. And this is one of the most important ones because, as you know, election integrity and our elections have to be upheld. And that means we have to strengthen the rules and the laws that are in the state of Michigan. At the same time, we've got to uphold the laws that are already on the books, and that involves you getting involved. If you'll notice at the bottom, it says we need you in 22.com. It's an easy place for you to go to sign up. And when you sign up there, you're going to get our emails. We're going to identify you by county, and we need to activate you, and we're going to get you involved to help serve as a poll worker in both the August primaries and in this November's election. We have been way underserved. The party doesn't do it, so the grassroots is going to. And it isn't just us at Stand Up Michigan, it is grassroots organizations all across Michigan that are collectively working together at a campaign that is being called, and I'm just going to show it to you here. I'm going to get it up. The Michigan Election Protection Team is where it's at. Okay. And that is a representative of all of us. We're looking to recruit 5,000 people to help us secure the elections for 2022. And we need you to get involved. And if you're signed up and get our emails, you're going to see links to those. But it is vital for us, again, to get involved, not just to participate in social media broadcasts and whatever. But I do want you to spread this word. I want you to share this as much as possible. And again, by this weekend, I want you to be watching your own mailbox for Secure My Vote. It actually will be stating, I've got the envelope here. Let me just look that up real quick, see if I can get a picture of that potentially for you that you can read. It says on here, official petitions for real election reform, including a strict voter ID requirement. That's what's going to be on the envelope. And that is going to be coming to your home in this next 2 to 3 weeks, 2 petition sheets. That's 20 signatures. We're asking you to give us 2 hours of your time to just get your family, your coworkers, your relatives, members from your church, a local sporting club, event, VFW, I don't care where it is. Work to get 20 signatures, either all from one county or do a sheet from 2 different counties. One maybe for your work, one where you live. If only 25% of the people that are getting these in the mail fill out half of their sheets, we will complete this petition initiative. And by the way, this petition, Secure MI Vote, that petition will do 4 things. It will force voter identification for all people. Number 2, it will not allow absentee applications to be mailed to anyone who doesn't request them. Number 3, those applications will need to have a voter ID or a last 4 of a Social Security when they request an absentee ballot. And number 4, which is going to be very important as I get into the details of this, it's going to stop the Zuckerberg money and the outside money from helping control our elections. So I want you to sign up, if you would, at weneedyouin22.com. We're going to join together. We're going to get thousands of us in order to make a difference. And we just want you to be a part of the solution because it will, again, never come from the government. Have a great evening, and we'll get back with you this weekend. Spread the word and spread this video so people can hear the results and the comments by David Coleman. We appreciate all your time. Have a great evening.